having the opportunity to take a look at what our partners have displayed for you at the Expo Zone, plus, of course, mingling and networking and sharing ideas and thoughts with your fellow attendees for our summit. Thank you for joining us back here. Once again, if I could request those of you seated at the back to kindly occupy the seats in the front, and those of you present inside the hall, requesting you to kindly place your mobile phones on silent mode. Now, before we resume with today's session, it's an honor to take this moment to acknowledge our partners whose contributions has definitely made IDS 2026 a huge possibility. So special thanks and shout out going out to our presenting partner, JioHotstar, co-powered by National Payments Corporation of India and Get ePay in association with Meta. Starting off the second leg of Day 2 of India Digital Summit 2026, we have for you a fireside chat focusing on the topic practical strategies for future AI content regulation. For this, allow me to welcome our speakers. This afternoon, we have Mr. Anil Lale, Executive Vice President and Head Legal, JioHotstar. And conducting this fireside chat, we have with us Ms. Sneha Jain, a partner, Saikrishna and Associates. Please put your hands together and join me in welcoming our speakers on stage this afternoon. Thank you, speakers, for joining us. It's a true delight to have you share with us your thoughts and your views. Without any further ado, let's dive right in, talking about practical strategies for future AI content regulation. Ms. Sneha, I'll let you lead the way.
Thank you. Thank you so much. Good afternoon, everyone. And I hope everyone has had their bellies full so that we can start the hopefully invigorating discussion that will wake all of you up. Anil, thank you so much for coming for this. I think one of the discussions that we've been having when it comes to AI content regulation and particularly media-related entities is how do you ensure that you protect your IP when media companies are using third-party tools which are based on AI usage, LLMs, could be big tools, could be small tools. Because at some level, JioHotstar is leading the way. For example, I was just hearing yesterday about all the real-time dubbing that is happening on the cricket side of things. So how do you ensure that when you are using these tools, you protect your IP?
Yeah, no, that's a great question. And we are in the era where AI is something that is unavoidable, especially if you are in the creative industry. But while we use AI, there are umpteen number of tools that we come across. And these tools actually have click-wrap agreements. And when you are clicking these agreements and uploading the content onto these tools, we need to take a moment and think, are we actually compromising our IP? And how does this compromise happen? Once we upload our content onto a tool, that is going to become part of the model, that is a public model, unless and until you have a clear opt-out option. And if that opt-out option is not there, then you are just compromising the IP that you're uploading. So when you're creating a content using the tool, and that tool is training a public model, that means that you are actually handing over your competitive advantage to your competitors, right? So your question mainly was on the practical side of it. So how as JioStar, how do we tackle this? So we started this journey sometime back when we started analyzing these tools and the terms and conditions, and we realized that there needs to be a clear governance policy, first of all. Then there needs to be a clear education that needs to happen within, because unless and until the people who handle these tools understand how it needs to be handled, then it opens up a port where data leakage as well as IP leakage happens. And once it flows into the public model, it is just like you opening the door and putting out all your furniture out onto the ground and saying that, okay, whoever wants it, take it off, right? Or whoever wants it, can use it. So apart from the governance policy, which clearly puts out how an AI tool can be used, we also launched an internal app which basically requires any user of an AI tool to come on board that particular app and fill up a the required fields, which is kind of self-guiding fields. Once that is fed into the app, it creates a flow where it comes to the legal team. Legal team basically hunts for any kind of clauses which requires the IP that we have uploaded for the purpose of processing being licensed to the tool itself, and even grants them the right to create derivatives. And we have seen that so many of these tools actually require such terms to be accepted before the tools can be utilized. Once we clear the tool, then it goes into the workflow where the cybersecurity team looks at the plumbing of the architecture of the app and ensures that the architecture is safe, and whatever the options of not training the public model, all those things are available. And then it goes into production where people can actually utilize the app. But apart from that, we also, when we look at sensitive or very premium IP, what we do is that we do not even allow a tool per se to ingest this content. We deploy it in internal instances itself. That means it's a walled garden. While the intelligence is available internally to us, whatever we train or however we use it, it does not flow back into the public model. So that is how we create a moat around JioHotstar or JioStar to ensure that our IP is not flowing back into the public models, at least not in the genuine way, or at least not in the bona fide manner.
So it seems from what I'm hearing from you is that there is a lot of effort and manpower which is going into it.
Yeah.
You have an internal app, you track all the usages, all the requests for use of AI tool for the particular purpose. You have a cybersecurity team.
Yeah.
I think we have a lot of startups and small companies in this room. What would be your suggestion to them? Because I don't know if they would have this kind of manpower to handle it.
That is true. So, yes, we handle not only our IP but also third-party IP. So we need to be extremely careful about what we do, and the kind of IP that we handle also, specifically third-party IP. We need to be really sure that we do not get caught between the fight of giants kind of situation. But for startups who actually need to use this kind of a tool, I would suggest that first of all, before clicking and accepting the terms and conditions, at least see if there is a toggle button which allows you to opt out or allows you to not train the public model, which most of the tools have. And if you do not have that option, do not use that app, because you may get a speed boost, but you are surrendering your sovereignty by using that particular app. And most of these apps even may say that it's free. But what actually may be happening is that the product which is being fed into the machine may be yourself or your own IP. So it is not actually, lunch is free, right? So that is one thing that I would say. And another thing I would say is to also look at open source models which can be deployed in local machines as well. When processing happens in your local machines, the option of the data flowing back into the public models also are reduced. So these 2-3 things that if you actually follow, maybe you can reduce the chances of your IP leak also happening.
This, I think, the part that you talked about, opting out and reading the fine print before you choose which AI tool to look into, is very important, because I think recently there was some litigation, I remember, where there were news reports about how somebody was creating confidential IP, and they'd used an AI tool which they had not opted out, and it actually went back into the tool, and some competitor had managed to find out about information about it. So I think that's a good takeaway for, at least if you don't have the manpower, read the fine print before you choose which tool you want to use. Coming to I think the next level of the chain that happens when you create content. Let's say you've created content now. JioHotstar has been in the news recently for being the first media company to come up with a fully AI-powered TV show, Mahabharat. Considering all the issues that we have today globally, which are unresolved regarding ownership in AI-created content, how is JioStar, or what do you suggest people do to kind of protect? Is it even protectable under IP? And if it is, how do you ensure that the protection continues?
Yeah, no, this is the biggest conundrum that any content creator faces today. And as I told earlier, you cannot imagine, at least going forward, you cannot imagine a space where you are not using AI to create content. And uh, if you have seen the promotions of our show also, the crux of the whole thing hangs on one word: powered and not generated. Why we call it AI powered and not AI generated is because when you hand over the creative process to the AI, that is where the law draws the line and says that you do not create a copyright, because there is no human involvement in the whole process. The modicum of creativity test, if you look at the Eastern Book case, the modicum of creativity test is clear, right? As in, if you need to claim copyright, there has to be a modicum of creativity, and that has to come from a human being. Now, how do we? I won't use the word that how do we solve this issue. We are also kind of tip-top, sensitively trying to understand and handle the issue. Our law is not very clear whether, even if it is AI powered, do we get the the copyright in the final product and all the constitutional elements in it, or how we can move forward. But at least the direction the world is taking is in such a manner where you use AI as a tool, as a paintbrush, as a camera, where the actual creativity is being contributed by the creative team or the creator himself. In our case, what we do is that, first of all, we have already put a system in place to ensure that any prompts to create any content is always logged, and that logs are unalterable and can be audited. Again, this is because we invest a lot of money in creating content, and from that perspective, we really require to demonstrate our copyright also. So what this does is that it shows that, let's say, Mahabharat, let's take Mahabharat, though it's a licensed content, but we have a lot of other content which is getting created by us also. So what we do is that whenever there is something that gets created, every log, every prompt that we give is recorded. That means, let's say there is a particular scene that has to be generated. And that generation, here I'm using the word generation because that piece has to be generated by giving an elaborate prompt of that particular scene. And once that scene is generated, then there are a lot of modifications that happens in the post-production, color correction, all those things into one particular scene. That scene may be 3 seconds only, right? But that screen is under, there is an underlying work which is a script. There is an underlying work which may be a musical composition, which again will have various other prompts. So all these things come together to form that one scene. Now this arrangement of these scenes are also different, as in that also is done by an editor. So it is not that you put a general prompt or even a specific prompt and create the whole series. It is an arrangement of various scenes, various underlying works, which culminates into the final product which you see as the cinematograph film. So even if the law is not clear about how we earn copyright in the pixel, at the end of the day, the overall picture, the copyright is clear. That is the cinematograph film that we create, even the scenes out of it which we create, the arrangement, everything, we still can claim copyright. That's how basically we are dealing with the copyright situation currently.
This is very interesting. And for those in the room who may not understand the distinction, just a very quick IP 101 explainer. Prompts and a combination of prompts, to my understanding, are separately protected as a literary work. So like you have in a film an underlying script, the detail and the depth with which you will be creating a prompt is separately protected as a literary work. And using those prompts when you create, let's say, a still, which then a series of stills becomes the moving picture, a cinematograph film, that is separately protected. Now, very interesting, just a side detour, if you don't mind, there was the US case on Zarya of the Dawn, where the US Copyright Office rejected protection to the film, which was created, it was a short film, on the ground that the prompts that were given, the series of prompts were, I mean, that was not the issue in discussion regarding their protection, but it was found that the series of prompts were not creative enough for the cinematograph film to have had significant human contribution. So what I'm hearing from you is that if you're creating IP using AI tools, it's not just the prompts themselves that have to be, logged and protected, but the prompts have to have significant contribution of humans in the creative element of the artistic work. Yeah. So it can't be that you simply have, let's say, a 10-line prompt which talks about a scene where there is, a boy and a girl holding hands walking on the street. But the prompt has to be detailed enough to identify this is where you want the sun, this is where you want the shadows, this is where you want the camera lighting, to be reflected, etc. For that creativity which is coming on the screen to have come from the human.
Yeah, so that is one way to look at it. The other way to look at it is that you also, whatever is generated by the AI, you look at it as an intermediate asset. What do I mean by intermediate asset? Once that creation happens, take that particular content that has been created, and then there is a lot of human effort that will go into it, which is the color composition correction. There may be post-production, and also the most important thing is the arrangement of the scenes. For example, if you have maybe 200 scenes to create the storyline, that storyline is created due to that arrangement. That is point number one. Once that arrangement happens, for that arrangement, there is a separate copyright. Secondly, the final product is a cinematograph film. And if you look at the Copyright Act, this is slightly technical. If you look at the Copyright Act, that is one work which does not actually require human authorship. It can be, the owner is, and the author is always the producer. And the producer need not be a human, it can be a corporate entity also. So from that perspective also, you get one more layer of copyright added to the whole thing.
It reminds me of those, as a child, I used to play with those flip books, which were animation books, where what I'm imagining is that each scene is a page of the flip book and the editor has to stitch all of them together and then add on to the creativity to make sure that the animation is running properly.
That's right.
That's very interesting. Since we're talking about copyright law, this is a question that we missed asking you yesterday. Because of your flight delays, we couldn't have you on the very interesting panel that we had. But I'm not going to let you go without, sharing your views on this question. Copyright as a law was created because of the invention of the printing press, which, made copying as an activity and reproduction as an activity very easy. AI is today changing that paradigm by making learning as an activity, pattern-based, very easy using machine. So do you feel that copyright law is the applicable legal regime sufficient enough to handle this different activity? Or do you feel that we should look outside copyright law to maybe different legal regimes to come up with a different kind of solution to the scale at which AI is disrupting copyright works?
Yeah, it's a very interesting question actually. If you look at copyright law and how it is evolved, you're right. Copyright law came into existence when printing press was invented, because till that time, copying means someone has to sit and write each and every page or paint the same thing. So there was no mass scale of copying that was possible. That first mass scale of copying became possible with the printing press. When Copyright Act came into being, it only was to protect the value which is owned by a creator and ensuring that the creator continues to derive that value. That is the sole purpose of copyright at its core, if you look at it, right? So today, if you look at it, yes, the printing press permitted or enabled, mass scale of copying. Internet enabled mass scale of distribution. Now what is happening is, at the end of AI, it is actually moving upstream. The value extraction is moving upstream. Where does the value extraction happen today? It happens at the point of training, the data sets. I seriously believe that the future of value extraction or value creation is going to be in creation of models. Means models are made of data sets to which the fuel is the content created by human beings, right? So models are going to be the new IP of tomorrow. Today, I'm when I talk to you, Sneha, you may argue that models are only a set of instructions. It's a statistical this thing. It's not an IP at all, right? But if you look at it, that models are the ones which basically analyzes how a content creator thinks, what his styles are, and all these things are turned into statistical models, which means which are also called model weights, and that model weights are able to create absolutely completely new works. Now, if we dealt with a situation when the printing press happened by ensuring that the value extraction has value creation happens, that recognition was given, that the value creation happens there, and an economic right was given to the author there, right? Regardless of the printing press and its copying ability. Similar things happen with internet and distribution as well. So today we are at the cusp of a new place where we need to understand that the model weights or creation of model weights is the new form of extraction of an economic advantage. And there, the participation of the owner and the author of those works are important. And what the law should focus on is to create a partnership between the AI engines as well as the authors, so that there is a symbiotic relationship, and it needs to continue to feed also. It is not that today AI has learned everything, but the human genius will continue to amaze even AI, because they will create, that only can create absolutely amazing, stunning new a new Van Gogh comes with a completely different style that the AI has never seen. That is still going to be new for the AI. Our social way of working, the way we think, the way we act, the way we dress up, everything continues to change. If the AI does not learn from all of that, it will still become stagnant. So AI will always be dependent on this, and this particular creation where the creator creates new works, that value extraction needs to be protected, and the value needs to be protected, and the creator needs to be part of this economy as well. So when I'm talking about model weights and the IP involved, there was this new case also I came across, which is Gemma versus OpenAI. The German Munich court actually gave a ruling saying that the lyrics which were part of a model is actually a reproduction of the lyrics, and because of that there is an infringement. So I'm just deriving a logic out of it. If a lyrics can be part of the model and it can be considered as an infringement, what stops any court from viewing it in a manner that any lyrics or any content that is part of a model is a reproduction, and it creates an ownership as well? So a model IP is not far away, and I think that's going to be the future for all of us.
So what I'm hearing is that copyright law sufficiently safeguards the fears that authors and creators have. Because ultimately it's about economic extraction of economic value from the work, and whether it's through reproduction or whether it's through learning. I think then the only question that remains, and I think we'll see if the audience has any questions after that for you, but the only question that remains to my mind is there are multiple licensing models being discussed on how to compensate the creator authors, voluntary licensing, compulsory licensing, or a hybrid approach where you have compulsory licensing, but the author should have the right to decide whether they want to allow a model to use their works or not. So how do you suggest young startups navigate this uncertainty, which is still not clear in the regulatory field, to ensure that they don't end up with huge potential claims in the future which they have not accounted for in their balance sheets?
Yeah, look, I'm never against machine learning or AI startups and AI learning and creation of content and all those things. But globally, if you're looking at today, voluntary licensing itself is a multi-million-dollar success. It's growing at a 20% CAGR today, right? And if something is working, and there are enough and more AI companies which has come into the foray, and they have been licensing content, they have been creating content. And when you're licensing content, one more thing is there, is that you get quality content. As in, if someone is licensing from Disney today, Disney is going to give them the kind of content in the way it is best possible for the AI to learn and reproduce or create transformative content using that Disney content, right? And a voluntary licensing model, if you look at it, has worked also because at the core of the Copyright Act also, when we are looking at the AI startups, we also need to look at the content creators. The content creators, this is their bread and butter, right? If the bread and butter of a genius content creator is taken, let's, for example, say A.R. Rahman. A.R. Rahman's content is taken and put into AI, and he is being paid the same kind of royalty, which is a fixed royalty amongst maybe me, who also sings with my own bad voice and puts 20 other songs in that, and that also some way, let's say, makes its way to the training model. And I'm also getting the same kind of this thing. He's also getting the same kind of this thing, and it is all based on some model where it's this number of content which is being part of the whole weight. How is that fair? So what I'm saying is that the core of copyright also is the right to say no, and to extract that and to get as much value as the content creator believes is there for the content. And his compulsory model, what it does is actually is to nationalize private property. And is that the right approach is what we need to look at. As in, it actually, yes, it may enable a few AI startups, but it's actually affecting the creative economy. And the orange economy is something that is supposed to hit billions of dollars in the next 6 to 7 years. And we should be careful about how that orange economy is also dealt with.
Okay, that's I think very interesting. So compulsory licensing effectively equalizing differently valued works at some level may seem progressive for the industry, but what you're suggesting is it could actually be harmful because it is taking away value from works which...
and not just value, actually, it actually takes the competitive advantage also out of it. For example, let us just take our own example. Let's say our competitive advantage is our content today, right? And our content tomorrow is going to become, a lot of it is going to become AI-generated content and all those, AI-powered content and all of those. But for powering that AI, we need the competitive advantage of having that particular model weights fine-tuned to the extent that we can deliver the best of the content to our audience. And, you know, a lot of money will be invested in creating that content also. Now, if the same, all the content that we create, which we feed to create our models, is also being made available as part of a public model, and that is available to our competitors, what is the competitive advantage there? So that also creates an unfair
compulsory
trade.
Licensing brings that in.
Exactly.
Thank you so much. I'm going to open it for audience questions. If there is anything that anybody has actually been awake enough to listen, please feel free to raise your hands and ask. Otherwise, we will, I think, have 4 minutes given back to you from the panel time.
Yes, please.
Yes.
Requesting you to kindly introduce yourself and then proceed with your question. Keep your hands raised so my associates can identify who you are. Yes, sir. Please introduce yourself and kindly proceed.
Gaurav. We work with a lot of human triggered and then AI modified or AI powered content. So a situation where a human being starts with, let's say, an image, a real human owned image or clicked image or created image, and AI kind of works around a video or whatever. And that from a IP perspective or a ownership perspective, that video has both components of what the human. So how should the IP ownership be decided? Of course, it from the perspective of the platform which is generating the video and the human. Is there a third entity that the IP belongs to out there, or between the two they can decide that this IP belongs to you, and that's enough? In the good old days where there was no AI, obviously the contract was between two entities, but how would that be done now? Thanks.
Yeah, no, actually that thought process is an amazing thought process. Basically, I've been trying to instill this thought process internally as well. Don't go and just give prompts to create content, but give an underlying work to the prompts as well. So what you are saying is that you are giving an underlying work to the machine to create an output, because what that does is a brilliant thing for you. What that does is that the underlying right, the copyright, still vests with you, and even the produced content, no one can debate that there is no IP in it because there is an underlying IP that has gone into creation of that. Now, only thing that you need to be careful is about the underlying IP. If it is an image of a person that you have clicked, it is not just copyright. There are other rights also which comes into play, which like the personality rights, the personal data, DPDPA, the act that has come in, all those things come in. As a performer, that person's rights, have you procured it under the Copyright Act? So if that is there, then your underlying work is protected. And that underlying work, once it goes into the tool and then an output is created, it is a clear link chain that you create of IP to protect your work. And I think that's the most secure way of going about it.
Got it.
I'll just add a nuance to this, sorry. The underlying IP is yours, which I think is very clear, a good practice, people must employ it. But also keep in mind that that is not the IP alone. Your question was about, let's say, if you take a still, you take a photograph and then create a video out of it. The tests, or the standard, or the thresholds that we discussed earlier, which is you still have, if you want that protection, so two questions. One, whether it is protected, the prompts that you put and the output that gets generated. And second, who owns that? Because you were asking something about in terms of, will there be a third entity, etc. AI per se, AI alone today, at least as the law stands today globally, will not be considered an owner of IP. It will be a human contributor along with the tool being used. And this is where the test comes in, that the human contribution has to be significant. So human contribution, not only in the depth of the prompts, but as Anil was explaining earlier, use that material to do the fine-tuning that you would otherwise do in an artistic work when you're creating it yourself. The color templates, the highlightings, all those aspects from the original underlying work that you anyways own IP to. So that will kind of ensure that the whole value chain is protected for you.
One follow-through question, if I may. The underlying IP belongs to another entity who is using my tool to enhance it into a video. Now, let's say I want to use that video to train my models. Do I have to take permission from the guy who owns the underlying IP? Is my question.
Yes, absolutely.
Got it. Thank you.
I think this is where we were talking about initially, to please make sure reads the terms and conditions. Whichever app you are using, please everybody make a note to ensure you read terms and conditions of this.
It's my own tool, so yeah, I'll frame it accordingly. Thanks.
We have time for one more question. Yes. Anybody with a question? Once again, I would request you to kindly raise your hand. Either me or my associate will join you. Please proceed by introducing yourself and then proceed with your question. Do we have any questions for our speakers on stage?
I think we can get off now. This.
Keep your hand raised. One of my associates will join you with a mic, requesting you to kindly introduce yourself and proceed with your question.
Hi Sneha, hi Anil. I'm Sanjana. I'm an associate at Lawn Care Partners and I work in the TMT and sports space. So I had a question for Anil. So this is rooting from, I did watch the JioHotstar Mahabharat movie and you mentioned that, I read reports that it was 100% AI generated. However,
AI powered. Let's use the right word. It's AI powered. It's not AI generated.
Okay, my bad. It's AI powered. So just wanted to ask a question on. There's a lot of dialogue around how AI related, there's a lot of environmental impacts around AI generation, right? So, for example, a recent Harvard Business Review article said that the global AI demand. It's projected to consume billions of cubic meters of water by 2027. So just wanted to understand, has JioHotstar considered this or has implemented anything in place to sort of tackle the kind of negative environmental impact this could have, by using so much AI in any sort of content creation?
So first of all, the kind of AI content generation, AI usage for content generation is a very minimal thing, first of all. The environmental issues that you're talking about is mainly on how the GPUs powered by the AI tool itself, how that consumes electricity, right? That's where you're talking about, what you're talking about. That is basically something which, as a as a global issue, everyone is tackling. As far as JioHotstar's steps are concerned, we have our own lot of our own things that we do as part of our CSR, which also leads to preservation of trees and all other things. But again, not targeted specifically at it. We are still trying to tackle the copyright aspect of it and trying to make sense of how to use AI. So once I think AI comes into a mainstream, like even today, if you look at it, 99% of our content is created using normal people and normal cameras and all. AI is just powering certain content. It has not yet come to the mainstream. When it comes to mainstream, as a leader in this market, I'm sure we will also be thinking on the fronts of environmental protection and other things as well.
Just to add my thoughts to it, technology in every form has always struggled with environmental safety. It's not just from an AI perspective. When cloud computing came, that became an issue. When EVs came, we're still, struggling. I mean, from the Industrial Revolution, for example, for that matter, when factories came, that was an issue. So I think environmental sustainability of usage of any technology is something that corporates as a whole consider, not purely because of one issue in terms of using a technologies like AI-powered LLMs, but generally as a whole, it's always separately considered from their overall business perspective. So I think that may be a question that needs to be considered from a larger perspective, as opposed to just AI usage leading to more electricity, leading to less water, leading to environmental imbalance. That's just my perspective.
Thank you so much.
Thank you. Thank you so much, Anil, for giving us your valuable time. And thank you, audience, for a peaceful and patient hearing to us.
Thank you, Sneha. Thank you,
Thank
IMI,
you.
and thank you, audience.
Thank you, Ms. Sneha. Thank you, Mr. Anil. Thank you for that very engaging and insightful discussion. Before I could let you go, if I could request the both of you to kindly stand at the forefront of the stage for a quick photo opportunity. Once again, ladies and gentlemen, please do put your hands together and let's give a round of applause to Mr. Anil and Ms. Sneha here, sharing with us their insights about practical strategies, talking about how we can govern the AI regulatory aspect of its content. Thank you once again, Mr. Anil and Ms. Sneha.